Okay, so we're going to go ahead and get started. Again, thank you everybody for joining today, and welcome to the Planning Lunches at Noon or Plan Monthly webinar series. Be sure to check out our Planning and Zoning Training website page shown or accessible at the link shown on your screen. Before we start, we're just going to go over some basic logistics. This webinar is going to consist of a presentation followed by a question and answer session, which will wrap up by 1:30 p.m. No later than that. Attendees that are online can submit their question at any time in the chat box. This feature can be accessed as shown at the bottom of the slide, and we will be recording this presentation portion of this webinar. However, we've disabled attendees' microphones and cameras. So with that, let's go ahead and get started. I'm going to turn it over to my colleague, Stephanie.
Thank you, Noah. Welcome again to the Plan webinar. It's zoning amendment time. I am Stephanie Verdile. I'm a principal planner with the Office of Planning and Development. With me today is Stephen Buckley. He is legal service counsel for the New Hampshire Municipal Association. And also today is Jennifer Gilbert. She will be jumping in to discuss the floodplain amendments ordinances. So as we move along here, let's get into some of the topics that we're going to review today. So why and how do we have zoning? What is a zoning amendment? The zoning ordinance's relationship to other municipal land use regulations, the floodplain map adoption process, what to consider for zoning amendments, what kind of starts the process. There's a few different legislative body processes and how these amendments are voted on, the notification requirements for zoning amendments, and then the ballot requirements, what's supposed to be put on the ballot for the voting. And then we'll wrap up with the question and answer period. So as we move along, why do we have zoning? So the creation of why we have zoning, how it all started, can go back to 1916, back in New York City. You can hopefully make out clearly in this cartoon picture of the construction of the Equitable building. The problem that this building construction presented was that it took up the entire lot and completely blocked all the abutting properties view for light, air circulation and things like that. So this city of New York said, well, it seems as though we need to have some type of, regulations in place to prevent that from happening. So that is how we come about getting to zoning. So zoning, the zoning ordinance is the end of the result of the legislative process. It's the document that regulates the height, building and land use density and land uses in the regulation and the municipality. And so how do we have zoning? In New Hampshire, it started back in 1925 with the enactment of the state statutes to enable municipalities to adopt land use regulations. Those planning and zoning RSAs are chapters 672 to 678. And specifically, how New Hampshire municipalities got that power was RSA 674-16. That was the grant of power. Gave the power, zoning grant of power, which gave the power to the municipalities to regulate land uses, specifically for the purpose of promoting the health, safety, and general welfare of the community. Taking that one step further is RSA 674-17, the purposes of zoning ordinance to lessen congestion in the streets, provide adequate light and air circulation, prevent overcrowding of land, and assure the proper use of natural resources and other public requirements. So those kind of how and the why and the where and the when zoning came into effect in New Hampshire and across the country. And so basically a zoning amendment is any change to the zoning ordinance that would include the language, the maps, or graphics. So understanding the purpose of zoning in the zoning amendment process and its relation to other land use regulations is important because it will in large part, that those are the documents that are going to determine whether or not your community is being developed and planned the way that the residents intended it to be. Zoning is that kind of avenue. It's that means to the way to get the community you want or get the community you don't want. So in order to start this zoning process and where it all begins, first you have to have the planning board, according to RSA 673(1), the establishment of a planning board. The planning board needs to adopt its bylaws and then a master plan. And we all know that the two required chapters of a master plan are the vision section and the land use section. So after you have the planning board established, they adopt the master plan and their bylaws, then it's up to the legislative body to have the adoption of the zoning ordinance, which was written by the planning board. After that, after the planning board has a zoning ordinance, the municipality can vote to have the planning board authorize site plans. So you need the zoning ordinance in order to have the planning board have the ability to do site plan review. And so, looking at continuation of the zoning ordinance relationship with other land use regulations, it's, the purpose and intent, of course, we all know that the master plan is at the top of the food chain when it comes to a municipality's land use regulations. So, the purpose of the master plan is to set down, this is quoting from RSA 674(2)(1). The purpose of the master plan is to set down as clearly as possible the best and most appropriate future development of the area under the jurisdiction of the planning board. To aid the board in designing ordinances that result in preserving and enhancing the unique quality of life in New Hampshire. So again, there's that master plan, planning board, the regulations in place to help the master plan and the planning board and the community carry out the wishes of the master plan. And that's done through zoning ordinance next, other land use regulations that follow. So while the master plan is, again, kind of at the beginning of the food chain for land use regulations, the zoning ordinance is pretty much the ordinance that ties them all together. You've got your subdivision regulations, site plan, excavation regulations, driveway ordinance, all ordinances under the purview of the planning board, as well as your floodplain ordinances. So as a little kind of practice pointer, you'll probably hear more than once throughout the presentation today, is that's why it's really important to do an annual review of your zoning ordinance up against your other regulations. You always want to make sure that they're all kind of pointing in the same direction and that there's no conflicts in them. So having said other, the relationship with other regulations, Jennifer Gilbert now is going to talk about the amendment process for floodplain maps.
Good afternoon, everyone. Can you advance a slide, please? I can't. So I just wanted to highlight, as a state floodplain management program coordinator, I just wanted to highlight this is kind of a little known state statute that we've had since 2007. And the purpose of this is to address the fact that occasionally FEMA releases new floodplain maps within the state, and they don't always align with our town amendment process. So we have this statute enacted to allow communities the ability to adopt these new maps and have the ability to change their floodplain ordinances without having to go through the town meeting process. So it's just a small little exception specifically for floodplain ordinances. When a new map does become, before the map becomes effective, communities will have to adopt it. So it allows the town's governing body to adopt the maps and then allows the community to amend their floodplain ordinance to replace the old map date with the new map date. So that's a way for us to make sure that the community meets FEMA's requirements without having to go through the town meeting process. We work closely with all the communities as new FEMA floodplain maps become available. So no need to worry. We will be coordinating with your community if you do have new maps coming, and we will get you through this process. But we just wanted to highlight it during this zoning amendment process. All right, thank you.
Okay, thank you very much.
We did just receive a question in the chat box. Stephanie and Steve, I don't know if you want to respond to it now, from Jim Contis asking who reviews the zoning ordinance. And I think that was in reference to the prior slide, Stephanie, that you were speaking to.
Well, let me just jump in quickly and say that, you know, the review of the zoning ordinance really certainly should include the town's municipal legal advisor, the town attorney, but that really can be done by any of the involved boards or staff who handle land use applications. You know, that review is something that you're doing all the time if you're in the land use department, because you're trying to help people make applications and you're interpreting it or making suggestions to people. It's going to be done by the ZBA. The ZBA, I'm on the ZBA in my town. We're constantly having to dive into details of our zoning ordinance to understand what it means. So that kind of review is going on a day-to-day basis, but you know, on an annual basis, probably a good idea for the planning board to just spend some time at a deliberate session, probably in August or September, and let's talk about our zoning ordinance, have a work session and go through it page by page or chapter by chapter. I certainly think that would be generally a good practice.
Yeah, okay, thank you, Steve. Thanks for the question. Okay, kind of along those lines. So what do we consider a zoning amendment? What type of topics should that, you know, take effect for the zoning amendment? So kind of what Steve was just, you know, talking about a little bit, going through the ordinance. Another good thing to work on is keeping track of what the ZBA is working on. What types of applications are repeatedly going to the zoning board? Do you have a lot of variances? Do you have a lot of special exceptions? That should be the trigger to talk to the zoning board, talk to the code enforcement officer, the building inspector, because if there's a lot of variances or special exceptions, it'd be a good opportunity to really kind of take a look at that section and see what's going on and why is that happening. Another thing is, you know, talk with your other municipal boards and staff. Are there any particular sections of the ordinance that they deal with that they're having problems with the language, or there's, you know, difficult things to interpret with certain sections of the zoning ordinance? Make sure that you review my kind of two favorite things to say about a zoning ordinance. The most important chapters of the zoning ordinance are your definitions and your table of permitted uses. So make sure that both of those sections of the ordinance match. Do you have a use that you don't have a definition for? Do you have a definition that you don't have a use for? So make sure that those two sections, you know, if you have both of those in your ordinance, under however your ordinance is designed, but the definitions and the table of permitted uses are pretty important sections of your ordinance, and they should really match. Again, make sure you're reviewing your zoning ordinance against your other land use regulations. You want to make sure you're all going in the same direction, and that also includes floodplain mapping. Make sure that you're keeping up to date with that. If there are sections in your ordinance that you cite state RSAs, for example, the wetlands or the Comprehensive Shoreline Protection Act, you want to make sure that you are including language in there that says, you know, RSA 485A as amended, so that your ordinance is keeping up with revisions to the state law instead of having to kind of go back and forth. And you know, a little practice pointer here, maybe that can help with that situation to do minor updates to a zoning ordinance, is what we like to call the housekeeping clause. And Steve is going to go through how to do the housekeeping clause, which I think it would be very beneficial and helpful to communities to take advantage of.
So I'm going to try something here and put in the chat what I would suggest as language that you all should have in your zoning ordinance. There are going to be occasions where there's a need to move paragraphs around or change numeration, changing from Roman numeral to Arabic numerals, whatever the case may be, and it has no impact whatsoever substantively on the zoning ordinance. So a number of years ago in a municipality I represented, we decided to amend the ordinance to give the planning board the authority to make these modifications so long as there was no substantive amendment. So this is the actual language that I actually recently copied and pasted from the zoning ordinance in question. So I would suggest that as one way to remove doubt that the planning board might have to deal with these kinds of minor and non-substantive corrections to the ordinance that makes it easier to understand or easier for members of the public to use. So I recommend that approach for your zoning amendments. And you could just put it in as an amendment that would cover you for future needs that arise for the board to make these modest assignment of numbering and sections to the ordinance, and again, making it easier for the use of the ordinance by members of the public and also by the staff. Yeah.
Absolutely. Fantastic. Thank you, Steve. It's really a great feat. It's really something that communities should consider taking advantage of because it kind of helps take away, the space and the number of amendments that you have from something that you could really use to be passed versus something just doing a housekeeping clause amendment. So they're very helpful. So thank you for that language, Steve.
Yeah, and I apologize. I hadn't clicked the paste button, so it's in there now. So you should have it. I had cut it in, but had not hit the arrow. So there you are. That's the amendment that I had previously had a municipality use.
Okay, thanks again, Steve. So some pointers, best practices for consideration of zoning amendments. You know what? Start early in the process. Summertime. I know it's summertime. But it's really the earlier that the boards and staff can start preparing, start working on what they want to go through for zoning amendments, the better off that you're going to be, because we all know how tight the schedule is for when you can post and have your first public hearing and your second public hearing. So really, really encourage the starting in the summertime. Having said that, starting in the summertime, consider adding, if feasible with your bylaws, or talk to how you can do it. The best legal way is consider adding a work session for the summertime. The work sessions just really help keep the planning board focused, help the public keep track of when the zoning amendments are being presented by the planning board. So, make sure that you're working on that with your work session. And that way, also the planning board is not working on applications as well as, trying to work on zoning amendments at the same meeting. So a work session, two meetings a month. I know it sounds like a lot and it's summertime, but it really is helpful in the zoning amendment process. And so again, keeping track, you're going to hear this reoccurring theme. Don't propose an amendment that's going to conflict with another section of the zoning ordinance or the master plan or your site plan regulations. Just make sure somebody's got to be in charge of that. Just make sure that you're not proposing any conflicts. The other, like I said, just don't take on too many amendments. Like I said, it can get a little confusing, get a little overwhelming for the general public to have too many amendments. Then you're running the risk of having some beneficial amendments fail, or because there's just too many of them. So don't keep your numbers down. I wouldn't go anything over 8, 9, 10 amendments. That's a little bit too much. One of my favorites, to take advantage of RSA 676-12. 676-12 allows the planning board to hold their first public hearing for zoning amendments 120 days prior to town meeting or town voting day. So that's, again, that would put you, depending on when your town meeting is, if you're traditional or in March, that puts you sometime in November, where you can start having those first public hearings. And again, considering the time of year, considering vacations, holidays, all that kinds of stuff, the earlier that you start in the process, the earlier that you get those first public hearings out of the way that maybe don't need a second public hearing, you're better off doing it that way to make sure you've got enough time to get everything that you want done.
We did get a question in reference to Steve's housekeeping language from Nick Strong saying, can we add typos and grammatical things that we find to that language as well?
That might stray a bit too far into a substantive amendment that only the town meeting or the town council has authority over. I'm not so concerned about typos as long as the typo is designed to make the ordinance harmonize with what was intended. Grammatical might be an issue. I would be a bit cautious there. I think you need to make sure that this housekeeping clause really sticks very strictly to non-substantive changes. And so I'd be a little concerned using grammatical corrections. Typos, that would probably be okay. Would strongly encourage any amendment that I have suggested that would perhaps include typos. Run it by your regular town attorney to get it blessed and approved before you propose that as an amendment.
And we just got another question. These all seem relevant to this section, so I'm going to keep going with them. Question from Denise: can we change plus add multiple definitions with one amendment, or must they be created as separate amendments?
I think you really should strive as much as possible is have each amendment to be consistent and centered around a particular subject. If you have many different amendments to your definitions and they're all addressing different subjects, it might become an issue that you've added so many different subjects. It's very difficult then to compose your ballot questions. So if you have a ballot question saying we're revising the amendments for frontage, lot, setback, I think it becomes very difficult and confusing for the voters to understand what they're voting on. So I would be a little bit leery having many different amendments in one ballot question. I think if you could, as much as possible, make sure the ballot questions are grouped around a kind of a single subject is the better approach.
Great.
Yeah, I would agree. And like I said, keeping in that theme, you really want to just keep things as easy as possible. Don't have a lot of language. Don't try and put anything that's confusing. You may have to sacrifice one or two amendments, the planning board decide what's the more important ones. If you're going to have several changes for definitions, just kind of be aware that it's a lot of information for people to take in. And you just want to make sure that you're being clear and you're not confusing people. Again, taking advantage of 676.12. Also, something to be aware of is 676.6, because that section, that RSA talks about the day that you post your first public hearing for a zoning amendment. If a planning board application comes in and something in that application relates to that proposed zoning amendment, say it's changing coverage for green space or something like that. After the zoning amendment public hearing has been posted, any subsequent applications that come into the town have to meet that proposed zoning amendment language. So it's a very precarious time of year for applicants to come to the planning board whenever you start that first public hearing notice. Because if the amendment fails, then they've just gone through, part over all of the amendment process. And now they have an approved plan that doesn't meet the zoning ordinance. So just make sure that you are aware of when you're posting things and make sure you're checking those applications that come in, whether there's also be building permits or planning board applications, to make sure that you're not creating a conflict and making an applicant, go through the process again. And that's kind of the case with everything for zoning amendments.
Great. Thank you, Stephanie and Steve. And it looks like we got one more question that just came in before we move on.
Sure.
I think this question is directed to Jennifer from Andy Bodnarick. What is the date for release of the final floodplain maps?
That date will vary based on the watershed maps that are released. So that is going to vary each time that a map is released. It had been done countywide, but now they're being released watershed. So we will definitely be in touch with the communities. You'll know well in advance, 6 months in advance before they become effective, what that date will be.
Great. Thank you, Jennifer.
Okay, and just let me back up two seconds here, just in case. I want to make sure that we covered it. I'm going to keep a running list of things all year, of what's going on. If you have some of those, you have several definitions that 2 or 3 of them just can't make the cut to get on one year, make sure you're keeping a running list to keep track of your amendments, and so you're able to bring those forward for next year.
One thing I just want to jump in and say about definitions, because it came up as a subject. I've sort of, I hate to use the term, but I'm going to use it, pet peeve. Please make sure your definition for frontage in your zoning ordinance makes sense for what your community wants to do. And it also harmonizes with the statute on building on Class 6 roads. So if possible, look at your zoning ordinance, see what your current definition for frontage is. It should say the following, in my humble opinion. Frontage means the adjoining public road is class Roman numeral 5 or better, or could be class 4, obviously, but something along those lines. There are many definitions out there that talk about a public road or a road without even defining what a road is. And we don't know what you mean if it says just a road. It could be a private road. It could be a class 6 road. It could be a class 5 road. So please, just look at your ordinance and change that definition. If you really do require people to have the lot abut a class 6 road, I can't believe I said that, a class 5 road, put it in your definition. Don't use the phrase public road. Don't use the phrase road. Just say class 5 road or better.
Yeah, that's great, Steve. And that is what I'm talking about when your definitions and your table of permitted uses are just one of the most important things with the zoning ordinance. How you define something. It should be plain language, easy language. It shouldn't be, definitions shouldn't really leave much room for interpretation. Like Steve was saying, a road could be a private road. What kind of road is it? Seasonal, class 6. So make sure that, what your definitions are expressing is clear enough language for people to follow and easily to interpret.
Okay,
So
we have a follow-up question related to the definition of frontage from Michael Aaron asking, what about lakefront frontage?
I guess I'm not 100% familiar with how one goes about defining frontage for the purpose of access to a lot on a lake or other water body. I guess, is it possible, and I don't know this off the top of my head, could you have parcels that only have frontage on a lake, don't have frontage on a public road? Here's the problem I think you have with that. You still have to comply with RSA 674-41. You still have to have access to that lot for the purpose of public safety vehicles.
Mhm.
I suppose you could have access through if you just had your fire department on your boat, but I just don't see how that was going to work. So, lakefront frontage, I don't think that fits into the general notion that you're dealing with when you talk about frontage, so you can gain access to the lot, which 99.9% of the times requires access through a public road, not through a waterway.
You could also check the RSAs, the Comprehensive Shoreline Protection Act. Maybe there's definitions in there. Honestly, I haven't worked with that RSA in a few years, but again, you want to find something that's kind of universal, that it makes sense to everybody. I wouldn't go down the rabbit hole of really descriptive definitions for lake frontage, natural high water mark, or whatever kind of words you think, but maybe check with the Comprehensive Shoreline Protection Act definitions, or contact someone at Shoreland themselves for that assistance, for that easy to follow, easy to understand language. That's the goal with your definitions, is the easy to follow language that's clear to people, where there's not, well, what, like Steve said before, what is a road? Name it. If you frontage on a class 5 or better kind of thing, just kind of be as clear as you can, less verbiage as you can.
And I see that there's a number of points that are made in the chat about there are homes obviously on islands. And I have to confess, I don't really know off the top of my head specifically how one deals with island homes that don't actually have frontage on a public road. So I apologize. I wasn't prepared for that today, but I imagine there are procedures either in the zoning and planning statutes or elsewhere which define the ability obviously to have a home on an island and not have frontage on a class 5 road or better. So let me just say, I would have to follow up with supplemental research to answer those questions. So I don't always know something off the top of my head.
Thanks, Steve. Thanks for the questions. Okay, so who starts this whole process? How do we get the ball rolling when it comes to zoning amendment times? So as we all know from all of our trainings and everything, what the planning board's responsible for, that's part of their main job, is take care of the zoning ordinance. You can also have the governing body, which is the selectmen, the village district commissioners, city or town councilmen. They all have the authority to propose zoning amendments. You have petition zoning amendments, where 25 or more voters of the municipality can petition for a zoning amendment. How that process works is the petitioned amendment is then submitted to the governing body. And that submission of that petitioned amendment has to be between 90 and 120 days prior to the voting day, town meeting voting day. And then the selectmen or the governing body, the selectmen, the city council, town councilors, it needs to be, they submit that to the planning board within a reasonable or timely manner. So you would hope that those petitioned amendments are submitted early enough in the process so that you've got enough time for your posting requirements. We all know and love the 10 days prior, 14 days in between. So you just want to make sure that there's enough time so that public hearings can be held. Those petitioned amendments and amendments that are submitted to by the governing body, they do have to have a specific language. You know, we can use the word shall. The language that we'll talk about it has to be included as part of the zoning amendment in that form, if it's submitted by the governing body or if it's submitted under a petition. You can't have, everybody's own individual language come forward as a zoning amendment. And we have some materials, and we'll talk about that also in a little bit about zoning amendment language. But it does have to be universal, and it's across the board for planning board amendments, governing body amendments, and for petitioned zoning amendments. Also to include on your language for whether or not the planning board recommends this. It's a yes, no kind of question that also should be included on your language. And just kind of make sure that whoever is proposed the amendment, whether it's governing body or whether it's petitioned, make sure that there's someone at the public hearing that can represent the proposed amendment, that can give some history, answer some questions of the board or from the public. Just don't submit something and walk away from it and have the planning board try to figure it out. So just make sure that you need to have the right language. You need to have someone there to represent it to the board at a public hearing. So now Steve is going to go through the process about how and when ordinances are amended. So go ahead, Steve. Thank you.
Before I do, I'm sure all of you are familiar with this great book that's also published by Office of Strategic Initiatives, also now known as the Office of Planning and Development. So I didn't know that answer about frontage on a lake, but it turns out it's RSA 674:41 Roman 2A. So if you have properties that only have access on a lakefront, don't have access to a road, your municipality may vote to accept, that is, so 674:41 says you can't build on anything other than a parcel that has access to a class 5 or class 6 or private road with permission from the select board. But there's this provision in 674:41 Roman 2A that says a municipality by vote of the legislative body can exempt island lots that only have access through water from the requirements of this statute. So I think that answers the questions of all of those of you who have island lot properties only, or some island lots that don't have access to a public road. Ideally, your town meeting would vote to accept those lots that only have access by water from the provisions of 674-41 having access to a class 5, 6, or a private road. So that's something to think about as an amendment. And I think that would be, and in fact, it has to be done pursuant to RSA 675. So it would be a zoning amendment that you would adopt. So maybe that's something to think about if you are island, you have communities with island lots. Think about adopting that as an amendment to your zoning ordinance to protect the interests of those who only have access to their properties via the water. So how are zoning ordinances amended? What's the basic legal requirement? Well, it is fundamentally always something to be done by the legislative body. So in towns, a zoning ordinance is adopted by the town meeting, and this is at an annual or special town meeting. So that's important to keep in mind, because oftentimes it is the case that during a year in which you might have other elections taking place, and the town needs perhaps to amend a zoning ordinance more quickly than waiting for the annual meeting, you can have the town call a special town meeting to adopt zoning amendments. And many towns that I've represented would do this often at a state primary. So you could have, and you could cooperatively arrange for an election, a town election, official ballot voting day, to take place on the same day as a state primary, and you could have voting on a zoning amendment. So just remember, towns, traditional towns, SB2 towns, can vote to adopt zoning amendments at a special or annual town meeting. And the standard is the annual town meeting, but you could also do it at a special town meeting. In cities and town council towns, the municipal charter determines how you adopt or amend a zoning ordinance. But in those particular types of local governments, you still have to have a public hearing process. Petition zoning amendments, by contrast, and by the way, it isn't always the case that in charter municipalities, whether it's a charter, a town charter, there are 7 municipalities that have town charters, and then there are 13 cities. In those municipalities, isn't always the case that you can do petition zoning amendments. But in a town, of course, petition zoning amendments are something available to any citizen. But petition zoning amendments can only be voted on at the annual town meeting. You cannot petition for a zoning amendment to take place at a special town meeting. So let's talk a little bit about the legislative body process. I think to some degree, Stephanie has already addressed the issue about petition zoning amendments, but let's be understanding about the exact time frame that applies to petition zoning amendments. It somewhat depends upon what type of town meeting you have. And in New Hampshire, whether you're an SB2 or traditional town meeting, your town meeting, that is the official ballot voting day, is always taking place on the second Tuesday of March, the second Tuesday of April, or the second Tuesday of May. Now, I don't mention them here, but I'll just say that village districts have an annual meeting, and I believe the statute, if I'm correct off the top of my head, takes place between the end of January and or the beginning of May. There's a timetable that sets forth when village districts adopt zoning. Not all zoning village districts have zoning. In fact, I suppose they are very few and far between, but there are village districts have zoning. But again, if you're a SB2 town or a traditional town meeting, your timetable for determining when petition zoning amendments, when everything else has to take place, starts with understanding when does the voting take place. So again, it's always the second Tuesday in March, April, or May. So the planning board, petition zoning amendments are received 120 days and 90 days before the official ballot voting day or town meeting. And that then tells you really what's the sensible time period to begin having planning board hearings. Now, you could start planning board hearings before the conclusion of the petition zoning amendment period. But why is that maybe not a good idea? Well, you don't know what petition is going to come forward. And that may be something you have to take into account as to what you're going to propose as a planning board or as a select board, for that matter, as a zoning amendment. So probably a good idea, generally speaking, to wait to the end of the petition zoning amendment period before you start your planning board hearing process. Besides which, the statute makes it very clear, once a petition zoning amendment has been submitted to the planning board, well, to the select board is supposed to turn it over to the planning board. And then at the next regular meeting of the planning board, you're supposed to meet and discuss when you're going to schedule a public hearing on the petition zoning amendment. So I think going back to, timetables and when you're going to start the process, we think it's probably the better approach. I think it's a better approach is to commence your zoning hearing process before the planning board once the petition zoning amendment period has completed itself. The basic requirement for all zoning amendments, you can't put an article on the warrant to adopt a zoning amendment unless the planning board has held at least one public hearing. And then the final proposed zoning amendment has to be placed on file with the town clerk and made available for public inspection by the 5th Tuesday before town meeting. That's the same law that applies to SB2 towns as traditional town meetings. So you count the 5th Tuesday before town meeting, and you've got to make sure the planning board delivers to the town clerk a complete copy of the substantive amendment. And also, I think the better practice is also to deliver the ballot questions. And I would encourage you to think about having your ballot questions, getting the assistance of the town meeting on doing the ballot questions. The regular town attorney to help you draft the ballot questions. One thing that I often see come up is the following question. Can we discuss and debate zoning amendments at town meeting? Well, for a traditional town meeting, there really isn't an opportunity to debate zoning amendments because you're going to vote at the official ballot voting day, which is always before the business meeting when you might have a chance to debate zoning amendments. So that's not going to happen. But what about SB2 towns? Well, you have this thing called the deliberative session, which takes place prior to the official ballot voting day, at least 28 days before the official ballot voting day. Why can't we discuss and debate zoning amendments at the deliberative session? Well, I suppose you can, but do you really need or want to? Because A, you don't want to give the voters the unintended expectation that they can amend the zoning amendment at the deliberative session, which they can't. No changes can be made to zoning amendments once the planning board has completed its final hearing and you've delivered the zoning changes and amendments to the town clerk. So why have a debate at SB2 time, a deliberative session to go over zoning amendments? Probably not a good idea. I think most moderators just take up the warrant and go straight to the first articles after the zoning amendments. But yes, you could allow a discussion, but I think to divert the potential for such a discussion, I would have the moderator do the following. The moderator would say, okay, we're going to take up the warrant, and the first 5 articles are zoning questions. And guess what? We have the chairman of the planning board or the town planning staff right in the back of the room with maps and handouts, and that person will be happy to explain all of the zoning amendments to you. So if you have questions about those zoning questions, please go to the back of the room and talk to that person. In the meantime, we're going to go right to the first article, which isn't zoning. I think that's probably the better approach dealing with these issues.
Great. We got a couple of quick questions in the chat. First one from Andy Bodnerick asking, what is a zoning ordinance protest petition? I forget if we address this later on in the presentation or not.
So a zoning ordinance protest petition is something that's submitted no later than the 7th day before town meeting. And what it requires, if you meet the requirement of the statute, it's RSA 675:5, I believe. Hold on a second. Again, I'm using my white book, which you'd always have at your fingertips. Makes it a lot easier. A zoning ordinance protest petition forces the town meeting, if it's properly submitted and signed by a sufficient number of affected parties, and the statute has some details on how many people have to sign it in terms of those who are directly affected by a zoning amendment, that would force that the voting on the article, rather than by a simple majority vote, and maybe I didn't say this, but zoning amendments are adopted by a simple majority vote. If a successful zoning protest petition is submitted and certified by the planning staff to the town clerk, then in that instance, you're going to have a 2/3 supermajority to adopt that zoning amendment. So it increases the amount of successful voting in favor in order to adopt an amendment, and it forces a supermajority to adopt it rather than a simple majority. So it's submitted under RSA 675:5. The deadline is this 7th day before the vote on the zoning amendments, which is always at the official ballot voting day, and then it has to get certified within that time period, and then there's a required supermajority to adopt the article.
Great, thank you, Steve. And one more question from Denise Mitchell. Does the town have any responsibility to publish the cutoff dates for receiving amendment petitions, or is the petitioner expected to know these states' rules themselves?
Well, that goes back to what our New Hampshire Supreme Court has said a number of times, that municipalities have an obligation to assist the citizenry in understanding how they interact with and use to their benefit the land use systems in their communities. And this has been stated by the Supreme Court in a number of cases. So I think it's a very good idea for the planning board perhaps to publish notification in a timely fashion throughout the fall about the opportunity to submit a zoning amendment by petition, maybe even also making known that the ability to do a zoning protest petition. And there's a number of ways I'm sure the community can get that information out by posting notices, putting things on the town's website. So yes, I agree that there's some obligation to keep the citizenry available, knowing about how the process works. And there's a number of ways that can be done, but I agree it's a good idea. There's no specific legal responsibility, but I think there's a general obligation that towns have to assist the citizenry in working with the land use system, and knowing how you do a zoning ordinance by petition or protest petition would be part of that obligation.
Great, thank you.
So just moving on to charter communities, there had been some requests made prior to the presentation today about how zoning amendments are handled in city and charter communities. In cities, zoning is adopted by the city council or the board of aldermen. There are 2 town council towns, charter communities, Hooksett and Peterborough, where the zoning is actually adopted by the voters. They've reserved that authority in their charter to the voters. In Bedford, Derry, Durham, Londonderry, Merrimack, and Newmarket, the zoning amendment are adopted by the elected town council. And then whether or not you can do a petition zoning amendment in those communities really depends on the charter. And so you have to turn to the charter to determine, can I submit a petitioned zoning amendment? Let's say a few things about the public hearing process. I just want to generally say about the public hearing process, how essential it is. Having been on a planning board and having worked through a number of zoning amendments, I really can't emphasize how important it is to make sure that, well, obviously you have a duty to make known to the public at large, you're having public hearings on zoning amendments, but knowing that, getting that information out and getting people to those zoning amendment hearings who have an interest in this particular issue that's being proposed by the planning board is very important. I'll tell you a quick story. When I was on the planning board in my community, we were proposing an amendment to our zoning ordinance that was going to create aquifer protection zones. Now, it just turns out that in our community, most of the areas that have good high quality aquifers in our community is also in our commercial industrial district. And as a consequence, when we proposed certain new restrictions on commercial and industrial activities that might be affected by, or that might have an impact on the underlying aquifers, there was a number of people who are property owners and commercial industrial users in those zones who were very concerned about how the aquifer protection zone was going to affect their ability to carry out activities, and certainly would potentially have an impact on economic development in our community. So it was a classic debate about trying to protect the environment while also trying to continue to encourage economic development. And it was a very important bit of information that we received, and we eventually decided, as we were able to do, have a second public hearing and change the zoning amendments and put in some relaxation of standards and ability to get special exceptions from certain of the requirements. So, but I just want to emphasize, for charter municipalities and town meeting towns, it has to be one public hearing at a minimum. If for town meeting towns, you can then have a second public hearing 14 days after the prior public hearing if the proposed amendment is substantively altered by the planning board after the first public hearing. And again, I can't emphasize enough, in that one occasion when we were adopting aquifer protection, it was very important for us to be able to have the time to do the second public hearing and still adopt our aquifer protection amendments. Because although we got that I would say important information at the first public hearing, we were able to use that to change the ordinance and make it what was going to be consistent with our concern to protect water under our aquifer water resources, but at the same time not discourage economic development. That's the last thing I want to mention. I'm not sure if I mentioned here or someplace else. You know, after you've done the entire public hearing process, the planning board really should have a final meeting and decide, is this a go or no go on each of those zoning amendments? You don't have to go to the ballot on everything that you've had public hearing on. And so at that last public hearing, the board should close the public hearing and vote. Now, are we going to put these 5 amendments to a vote? And each one should be taken up, you know, and should have someone make a motion. Madam Chair, I propose that we put on the ballot question number 1 on aquifer protection. And if you're not ready, or it's, you know, unclear that there's enough information gathered, you can just vote no, we're not going to put it on the ballot. And you can then wait for another, you know, a round of hearings at a subsequent year where you will address the issue on another occasion. And at that same time that you have closed the public hearing and it's the last one, you're going to vote whether to put all of the 5 amendments. Let's say that there are 5. You should also at that same time be voting on whether or not the planning board is going to vote to recommend or not recommend that particular amendment.
Great. Before we move on, we did just get another question from Ivan Quinchia. Sorry if I'm mispronouncing your name. If the community held a public meeting on a zoning amendment and did not bring this amendment to a vote at town meeting, and if only a minor change was made, can the town bring this amendment to a vote at the following town meeting without another public hearing?
I think you'd be much better served that you would dot your I's and cross your T's, and that if you made a change to the zoning amendment, it didn't go to vote, but you still came back the next year to propose it again, you still ought to hold a public hearing on that change before it goes to vote again. I think that's just a safer approach. You're going to have public hearings in the following year anyway. Why not just put that up again as a further discussion at a subsequent public hearing? Because the voters have to have a right to be heard on that issue, and they're not going to have that right if you just go straight to voting on the amendment at a subsequent town meeting. So no, I think the better approach is, you know, even though you elected not to go to a vote on that article, it had been changed. Now you're going to make you revise it again. And you go to the next town meeting to a vote on it again, there really has to be an opportunity for the public to be heard at a public hearing on that amendment. So let's talk about the public hearing and notice requirements. So every time you hold a public hearing, you have to give notice of it 10 calendar days. That's 10 clear calendar days. So it turns out to be 12 days. And notice has to be posted in at least 2 public places. Also be aware that there's this new requirement, and I've seen this in communities already, Under this statute, any person owning property in your community, including non-residents, can send you a notice that they want notice of any zoning amendments, and they are required to receive that notice by first-class mail or electronically. So that is something that someone can ask for. Notice should also be published in a newspaper in general circulation, or in the alternative, and this is new as of last year or the year before, you can post notice rather than in a newspaper on the homepage of your town website. So let's understand what that permission to do that differently than publication says. So the notice has to appear prominently on the homepage of the website. The notice has to state the time. The time that's stated in paragraph A, that the 10 days beforehand, has to remain on the website until the conclusion of the public hearing. So once you post it, you don't take it down until the public hearing is posted, the public hearing process is completed, and then it has to also be posted in 2 public places. So that is now an option, which does save the community some money, not having to publish it in a newspaper. You can now post the notice on your town website. And finally, you are not required, and I've seen this many times, and I don't think it's necessary, to publish the full text of an amendment as long as the summary of the amendment adequately describes the amendment and states a place where the full text is on file for public inspection. So you can save yourself considerable time and expense of not having to publish the full zoning amendment in the paper, but make sure, and this is very important, on the date that the notice is posted, whether on the website or in 2 public places, just make sure in your notice you say full text may be available at, and I would recommend the town library and the town hall, because those are the 2 places that generally are available to people who would come in and be interested. In fact, in my library, during town meeting time, they have a special table set up for zoning amendment copies of the warrants, and copies of the budgets and other things. So I just think that's a good practice. So let's talk a little bit about the notification and mailing requirements. So there are some new provisions in RSA, on the statutes, RSA 675:7, where if you have certain types of amendments, and these were changes that were made, I believe, in 2016, you might have a certain additional supplemental duty to give notice to individuals who could be affected by a zoning amendment. So be aware of this. Does your proposed zoning amendment change a boundary of a zoning district that affects 100 or fewer properties? If yes, notice of the public hearing must be mailed to all the owners of such affected property. Number 2, does an amendment change minimum lot sizes or permitted uses in a zoning district that has 100 or fewer properties? If yes, notice must be sent to the owner of each property in the district. And this notice doesn't have to be sent by verified mail or certified mail, but has to be sent by first-class mail to the address used for the property tax bills. So you go to the property tax warrant and you use those addresses for sending out these notices. And there is also a provision, because most of the time, from my perspective, and I don't know how it is in your communities, most of the petition zoning amendments that you see and that I have seen in the past are really asking the town to move this parcel of land from residential to commercial or vice versa. That's the most common zoning amendments I've seen by petition. And so typically in that situation, and as required by the statute, when you have that kind of a change, it may require this special kind of notification. The petitioner is obligated to pay the cost of that notification process. And there's actually a process in the statute that says that the petitioner doesn't pay within a stated period of time, and I think it's 5 business days after notice from the select board. The select board has the option not to put the zoning amendment to the planning board for consideration. So keep aware of these particular provisions, which they are binding on all the communities.
Okay, it looks like we got another question here from Lisa Stone. If a town needs to make a lot of changes, is it preferred to pluck out the parts that are wanted to change or to rewrite the section? And this was Lisa said, in relation to exclusionary zoning and available federal funds.
Let me just say about exclusionary zoning, and I apologize if someone take this to be unkind, but if you have 5-acre minimum lot sizes for residential zoning districts in your community, you've got a problem, and you really need to think about getting rid of 5-acre minimum lot size requirements. I just want to put it out there. Okay, moving on. If you're looking at a need to make radical changes in order to avoid being declared to be exclusionary, and this is either under the Chester case or under the workforce housing statute, I think, you know, it might be better to change an entire section of the ordinance in one fell swoop rather than trying to pluck things out. But see, that's a very hard thing to answer in the context of what you're trying to achieve. You're trying to avoid an issue that your zoning ordinance is exclusionary. So I think that kind of question, I really would have to defer to your regular town attorney and or your regional planning commission. Don't forget about your regional planning commission as a place to turn to help improve your zoning ordinance on these kind of issues. The other thing I want to mention is OSI, the Office of Planning and Development, also has an excellent municipal land use survey that has been done that is an excellent resource to turn to how other municipalities have gone about improving their zoning ordinance. So think about turning to that. Let's just go now to the question of petition zoning amendments. And I just have to forward this here. So as I've previously mentioned, 25 voters can petition to amend or repeal the zoning ordinance. You can actually do a petition to repeal the zoning ordinance. They're submitted to the select board or to the village district commissioners. And then at the first planning board meeting after the petition period, the board has to set the date for the public hearing on the petition. Petition amendments cannot be altered by the planning board. And this also applies to amendments, because understand, zoning amendments can also be submitted by the select board, by the village district commissioners, and obviously by petition. These cannot be amended by the planning board. Yes, the planning board is going to hold a public hearing, but you can't touch the content of what's been submitted by petition or by the select board or the village district commissioners. Only thing the planning board can do, and this is a very powerful, persuasive way that the board can impact what will take place at the voting booth. The planning board has to state whether it approves or disapproves zoning amendments. And my experience has been, if you have a petition zoning amendment and the planning board does not approve it, it's not going to pass. That's generally been my experience. So don't underestimate the importance of the planning board's vote on whether it approves or disapproves a zoning amendment. So with that, I'm going to let Stephanie pick up here and talk about the official ballot voting requirements.
Okay, thanks, Steve. So the official ballot, the official voting. So as we move into, let me get my bearings here for a second. So the municipal clerk, with the assistance of the planning board, before the board prepares the question for the final ballot, you should really sit down with the municipal clerk and really just have that second set of eyes and make sure that the language is uniform for the proposed amendment. We spoke a little bit about it, in earlier slides of what the zoning amendment language should be. So the zoning amendment language shall be: are you in favor of the adoption of the amendment to the town zoning ordinance as proposed by the planning board as follows? So that statement is for all types of amendments across the board, whether it's planning board, whether it's petitioned, or whether it's submitted by the governing body. Inside the parentheses for your topical description, you would most likely cite the particular title section of the ordinance that you're proposing to amend. And then some description. When you're thinking about putting zoning amendments up, try and give a brief description. You do not have to put the whole text of the amendment on the ballot. This is the ballot everybody's voting on. So keep the language as brief as you can with the, having said that, with a decent explanation so people understand. So once you move through and you finalized all of the language after the second public hearing, then that's when it's sent to the municipal clerk, and there's no, again, once after the second public hearing, there's no changing these amendments. You've gone through the process, it's been to the clerk, you've finalized the language, and this all has to take place to make sure the final language is the 5th Tuesday prior to your voting day. And again, so as we kind of just wind down here towards the end, you know, at the voting for the official ballot, they can't be amended after the final planning board public hearing. And something that we can touch on a little bit, but just as a quick practice pointer, so to speak. It's a good idea to have a representative at the polls when you're voting, or the deliberative session, either from the planning board or some planning staff that can answer the questions. I know my times in working in municipalities on, you know, deliberative session or voting day, that's where I spent the day, was with some amendments, so that if anybody had any questions about what was being proposed, there was staff there that could explain it, explain the reasoning, and kind of help people through the process. So those are really kind of have another really good practice pointer kind of tip to make sure that someone is there to represent. Because if not, then you're running the risk of all of the work and time and money and energy and effort that you put into having these zoning amendments. And if no one's there to explain it or help answer questions, then you're running the risk of having the amendment fail. So that kind of brings us to the end of the presentation here. Steve and I can go through just some resources out there that are available to communities when you're looking to work on zoning amendment process and the language and the intricacies of it. The American Planning Association website is helpful. They have good definitions. Another thing that would work for definitions is go to the dictionary. And as a matter of fact, Steve could probably tell you better than I, but even the Supreme Court has used Webster's dictionary for definitions to help with making an interpretation, with help with making a decision. So don't be afraid to use the dictionary because it's pretty universal language. Our website, the Office of Planning and Development and the New Hampshire Municipal Association, again, we have zoning amendment calendars that are going to be coming out. Ours is going to be available relatively soon, I believe. Walks you through the steps for all of the types of town meetings, traditional SB2, March, April, and May. And right now, you know, Noah from our office, Noah Hodgetts, is going to talk about our municipal land use regulation survey that Steve mentioned as well in the presentation. And Noah's going to explain that a little bit to help people understand how you can use that resource on our website for your zoning amendment process.
Sure. Well, thank you, Stephanie. So yeah, we're not going to go into details about how to use the survey at this time. What I will say is that our office, the Office of Planning Development, administers a municipal land use regulation survey that can be a good resource to research what type of planning tools surrounding communities have employed in order to get ideas and content for zoning amendments. Right now, we're in the process of doing this year's update. So I'm sorry to anybody who's probably received my numerous emails for the handful of communities that we're still waiting on to respond. If you're one of those people, please, I'd appreciate if you'd respond so that we can finish up and get this year's results out in a timely fashion. But just as kind of a general statement, we present the survey results are available in a few different formats. There's a downloadable PDF that you can download for a community snapshot of all the planning tools that each community employs, searchable by community. We have an interactive map that you can search for a tool by community, kind of glancing, moving over a map to look at, you know, kind of communities around you. There's downloadable Excel tables for each subject covered on the survey. And then there's also a summary article. So there's a lot of different ways to access the information, and the URL is contained on the highlighted text under OPD, Municipal Land Use Regulation Survey on the slide, and this year's results, the 2021 results, I hope, will be released before the end of the year. So keep an eye out for that. Thank you.
Okay, great. Thanks, Noah. Just to kind of review some other resources for you guys working on the zoning amendment process and your dates and your times. Chapter 39 of the RSAs is the time for holding town meeting. Also, chapter 40, which talks about the government of town meeting, that, you know, it may take you a little while to digest that, but that's where you come up with the town SB2s in March and April and May. So they're just referencing other RSAs out there that you should be aware of or familiar with as far as when it comes to the zoning amendment process. Kind of what I spoke about earlier in the presentation is that the planning RSAs, chapters 672 up and through 678. Steve's going to talk a little bit about chapter 672, just some little details about those ordinances. And again, just to kind of, we're going to start kind of wrap it up a little bit. We scheduled this to go to 1:30. We have to really hold that 1:30 deadline today. So we're just going to finish up really quickly. And so we would be able to have enough time to get to your questions. Also, just to very quickly say before we run out of time, I'm always available to have any questions answered after the presentation. Steve and I will be glad to help people out with that. So I just want to have Steve go over a couple things quickly with chapter 672 and just to be aware of the other RSAs that are all applicable when it comes to the zoning amendments.
So I put together just a brief list of things that you should know about in the statutes, RSA 672 and 674 in particular, that requires zoning ordinances to do or not do. Number one, there's actually 4 provisions in RSA 672:1 that basically say agricultural activities and agritourism, forestry activities, affordable low and moderate income, commercial and recreational fisheries, and family-based care, home care, cannot be prohibited or unreasonably discouraged by the use of municipal planning and zoning powers. So all 5 of those type of uses of land are, under that statute, given some special protection from unreasonable application of zoning. Now, you're probably wondering, what is unreasonable application of zoning powers? There's actually a provision of the statute that mentions that, but just be aware of this. I mean, the idea here behind the legislature is to discourage municipal zoning ordinances from unreasonably impacting those uses: agriculture, forestry, affordable low and moderate income housing, commercial and recreational fisheries, and family-based home care. That's number one. Number two, there are a number of other ways in which in RSA chapter 674, you are prevented from doing certain things, or you're required to do certain things under your zoning ordinance. For instance, you can't regulate out of existence amateur radio antennas that comply with FCC regulations. You should be aware that unless you say so in your ordinance, private takeoffs and landings from aircraft are considered to be an accessory use of a residential property. You have to actually step forward in your ordinance and say, we're not going to allow private takeoff and landings as accessory uses. Manufactured housing is required to be a permitted use in your community, and you have 3 options. You can have manufactured housing on individual lots, in manufactured housing subdivisions, or manufactured home parks. So those are all the 3 options. You have to have at least one of them. There's an agricultural presumption in the statute, which basically says whenever agricultural operations or activities are not explicitly addressed with respect to a zoning district or location, it is deemed that those operations or activities are permitted. Be aware of that. So you have to address that in your zoning ordinance. Municipalities are required to provide reasonable and realistic opportunities for workforce housing for low and moderate income. Municipalities cannot unreasonably impose zoning restrictions to thwart the ability of small wind energy systems from being in existence. And I've already mentioned, but I'll mention again, commercial and recreational fishing is protected so that no legislative body can adopt an ordinance that declares commercial or recreational fishing to be a nuisance. And finally, you're probably all familiar with this, but a municipality that has zoning has to allow accessory dwelling units as a matter of right in all zoning districts that permit single-family dwellings. So that's just a quick summary of kind of the do's and don'ts by statute for zoning ordinances in your community. Now, the last thing, I don't know if you want me to address this now, Stephanie, but we had received an inquiry about historic district zoning. Want me to deal with that?
Yeah, please. That would be great, Steve, because they are included. You know, we always talk about things kind of loosely, zoning amendments. This also includes building codes and as well as the historic district ordinances in part of all of these processes. So that would be wonderful if you could try and help that person out who asked a question about historic.
So the first thing I would just say that the person who submitted the question beforehand actually mentioned that a similar question is pending for being answered by their regular town attorney. And I always tell people, go by what your regular town attorney says, not what I say from legal services they hear at NHMA or even incidental, I suppose, legal advice you get from OSI. Yeah, or your planner. So really, go with your town attorney. So I'm not going to answer the detailed specifics, but generally speaking, historic district zoning under 674:46. The idea is the town meeting adopts an historic district zoning ordinance that says this section of town, and it could be an overlay district, then you have an underlying district, which is single family. And then on top of that, you have an overlay that says this particular part of our R1 zone, residential 1 zone, is going to be deemed a historic district. Once you've done that, then it enables the Historic District Commission to adopt more specific regulations about how uses of land within the overlay called the historic district are allowed to be modified or structurally changed, as the case may be. And the way the statute works is once the Historic District Commission has adopted its regulations, you can't get a building permit to renovate a structure in the historic district unless the Historic District Commission approves that building permit. It's actually a step in between the building permit application and the permit being issued by the building inspector. It requires a sign off from the Historic District Commission. So that's a general answer to the person who asked the question, but I would certainly encourage that person to really rely upon the opinion of your regular town attorney. I just would mention, someone asked, where did I get this white book? Okay, this white book, it comes out every year and it's put out by the Office of Strategic Initiatives, also to be known now as the Office of Planning and Development. Where do you get a copy of that book? You go to your Regional Planning Commission. The Regional Planning Commissions every year buy up large numbers of these in cooperation with OSI, OPD, and they make them available to your planning board. So I would do not pass go, do not collect $200, go straight to your office of your Regional Planning Commission in your community. Hopefully you're a member of it, and get your copy, because that's a really invaluable resource to have it at your desk when you're sitting at a planning board or ZBA hearing.
Yes, and we know that all, planning and zoning board members faithfully bring that with them to their meetings, or at least, while they're doing their homework for their applications, they're just like their master plan, they're checking the RSAs. So we're ready for Q&A, I think, at this point, if there's any left in the chat to take care of.
Let me just kind of take control back here. So here's Stephanie and Steve's contact information. And just a reminder that these slides and a recording of the webinar, as well as a link to a brief anonymous feedback survey, is available on the Planning and Zoning Training website page at the link shown on your screen in the bottom right corner. We'd appreciate you filling out the anonymous survey, as it helps us improve future webinars. Also on that page, I'll note there's several handouts related to this webinar, including additional best practices and tips, a timeline, and then the aforementioned zoning amendment calendars that our Office of Planning and Development has just published.
Yeah, thanks, Noah. Yeah, I wanted to just, kind of send that reminder that there will be more materials available next week on the website that will be included as part of these meeting materials, and the zoning amendment calendars is going to be part of that. So thanks for the reminder. So just kind of hang tight. The zoning amendment, New Hampshire Municipals Association calendar. Steve, your calendars are out, right?
Yes, in fact, I put in the chat URL for connection to our the copies. I just would mention that those calendars are not exclusively zoning. There's a lot of other town meeting stuff in there, obviously, but the zoning stuff you need to know is available for you to see in each of those calendars, with obviously 5 for the 3 SB2 towns and the SB2s, March, April, May, and the traditional towns, March and May.
Yeah.
Great. And I just put in the chat box a link to our office's zoning amendment calendars as well. So that URL will take you to the portion of the website where you can download the relevant calendar for SB2 or traditional, depending on what month your town holds town meeting. So with that, we're going to turn to, with the last 10 minutes here, to additional Q&A. I know we've been doing questions throughout, but there's still a couple questions left in the chat box that I want to get to. And just as a reminder, you can, if you're online, you can type your question in the chat box, excuse me. So let me just scroll back up and make sure we haven't missed any. Here, I think this is where we stopped. Our zoning ordinance has definitions sprinkled in many places. If we want to consolidate those definitions in one place without any modification to the definition, would that be a legitimate application of your housekeeping clause? And this question comes from Dave Katz.
I think that would be a bridge too far. I wouldn't put that into the housekeeping approach to dealing with that consolidation. I would really think you'd want to do that as a separate zoning amendment.
Great. Thank you, Steve. Okay, next question. Let's see. You talked about where to find the plur books. That's that. Ann Dowling wanted an additional explanation of why 5-acre lot zoning was a problem. Steve.
Because the Chester case from the New Hampshire Supreme Court made very clear that 5-acre minimum lot sizes are in effect per se exclusionary. It prevents people from building low and moderate income housing if that's the only or predominant form of density requirement in your community. It's just impossible to build affordable housing at that price, at that amount of density. So it's something you have to be aware of. You have to be aware of the workforce housing statute, but also the Chester case. I would try to get you a URL for that, but it would take me a few minutes. But it's based upon the Chester case. In fact, I think it's mentioned in the workforce housing statute. I think there's a reference to the statute was based upon trying to implement through an amendment to the statute to these requirements for zoning and planning. It was meant to implement that particular provision. Yes, and it is. I'll give you the name of the case. It's Britton versus Chester, 134 New Hampshire 439. So it's actually cited as part of the legislative purpose of the workforce housing statute. So be familiar with that case and talk to your town attorney about it.
Great, thank you. And we have an additional question about the White Planning and Land Use Regulation book. Is there a PDF option for that book? Being able to search it is highly helpful for finding things quickly during a meeting.
I'm not aware of one. Noah, I have to turn to you and Stephanie to see if that's something you have put together or make available.
To my knowledge, Lexis, our contracts is with LexisNexis. When, as you mentioned, the RPCs distribute the books for each community in their region. I do not believe that they offer a PDF option for sale.
In the old days, there used to be. In the old days, there used to be a CD in the back where people remember CD technology, but that's not anymore.
Right. All right, getting down here. Try to get through a few more of these questions. You think you addressed Ann Howe asked about historic districts, and then also asked about, is there anything different about zoning overlay districts as part of the zoning amendment process, or do you have to go through the same process basically?
An overlay is just taking a different layer of of zoning requirements and regulations and putting on top of an existing zoning district. So as I mentioned before, in my community, we put together an aquifer protection zone, which was an overlay over our commercial industrial district. And it put more enhanced requirements to protect the subsurface water supplies from activities on the surface of the land. So it's just adding a different layer of regulation on an existing part of the town that's been zoned residential, commercial, or industrial. It's nothing more sophisticated than that. I don't know, Stephanie, if you have a better planner explanation of what an overlay district is.
Well, you know, an overlay district, from what I've seen, some things you can use them for downtowns, for, you know, parking. I've seen them used for aquifer protection kind of overlay district. So if you already have, you know, existing parking regulations, or like Steve talked about the aquifer protection overlay district, you already have underlying zoning. An overlay district is something that is an addition, and it maps out the boundaries of that. So that's kind of where I draw the line, or how I kind of look at, you know, an overlay district for parking, like I said, or a specific wetlands district, or maybe a scenic byway kind of thing, where an overlay district has, you know, some little tighter boundaries versus a zone that would take up, you know, a larger part of the town. But you got to be pretty descriptive on those boundaries.
Great, thank you. And my colleague Michael Class, who's also listening on the webinar and manages the planning and land use regulation book process, did correct me. I was wrong. There is an ebook option that a community can request when purchasing the book. So thank you. Somebody asked about the role of the Housing Appeals Board. I think that's a separate conversation.
Yeah.
Stephanie, I know you put a link in that. Stephen, am I correct that NHMA will be offering a webinar about the Housing Appeals Board, I believe, in October?
Yes, actually, I did. It is in October. I don't know off the top of my head, but I believe it's the 21st of October. And I will be going into the statute, how the Housing Appeal Board is supposed to operate, and dealing with appeals on land use decisions that affect housing or housing opportunities in your community. So that is going to be something we'll doing in the future.
Great. Thanks, Steve. No, did we have anybody on the phone that we know of?
So unfortunately, since I muted everybody, you cannot, I am unable to unmute people on the phone to ask questions. So that is unfortunately not an option for us.
Okay.
Yeah.
Okay.
Just trying to see. Looks like we have not seeing, I think we've addressed all the questions. I know we have a 1:30 hard stop. So unless there's any kind of final burning questions, I think we're gonna wrap up here. Yep, not seeing any. I think we've answered everybody's questions. I think we're good. I want to again just thank Stephen Buckley from NHMA and Stephanie Verdile from the Office of Planning and Development for presenting at this webinar and answering everybody's questions. Hopefully everybody has a little better understanding of the zoning amendment process.
Yeah, thank you, Steve. Appreciate your time and your effort. This is you know, always helpful, always good to have you on.
Thank you, and I'm glad to be here.
Great, thanks everybody. And if you have any other questions that come up afterwards, feel free to reach out to us. We'll be glad to help you out as best we can.
Great.
Thank you.
All right.
Thanks, Noah.
Have a good day.
Have a good day, everybody. Thank you.